Hello and a very warm welcome to latest case analysis series by LawSikho. For today's discussion, we have taken up a decision by the Honorable High Court of Punjab and Haryana, which is dated 26th of November 2020. It was decided by a single judge bench consisting of Honorable Justice ALKA SARIN, and the name of the case is Vijender Kumar versus State of Haryana. So now let's proceed and understand the issue of law. So the court was to decide whether freedom of speech entitles a person to make derogatory remarks or post against any community or gender. Now let's proceed with the brief facts of the matter. So an FIR was lodged by two individuals, Savita Kajal and Kuldeep, and the FIR, it allegedly stated that the petitioner, in order to create disharmony, made insulting and objectionable comments on a Facebook post which was shared by Savita Kajal. And this particular post, it had a reference to Dr. B.R. Ambedkar. So the petitioner, in order to create disharmony, made insulting and objectionable comments on her post, and he also used filthy language and in order to insult two particular communities, first being Muslim women and women belonging to the SC category. Now, once these comments were made, an FIR was lodged under the following sections of the Indian Penal Code and Section 3, subsection 1, clause 5 of the SC/ST Act. So the first charge in the FIR was of section 153 capital A, which provides for promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts which may bring prejudice to maintenance of harmony among the society. And it further provides for offense committed in place of worship, etc., while the next charge being Section 295A, which provides for deliberate and malicious acts which are intended to outrage religious feelings of any class by insulting its religion or religious beliefs. And the last charge being Section 505 of the Indian Penal Code, which provides for statements conducing to public mischief, and it further provides for statements creating or promoting enmity, hatred, or ill will between classes. It also provides for offense under subsection 2, which are committed in place of worship, etc. So, this were the nature of the allegations which were leveled against the petitioner. Now, once the FIR was lodged, then on 31st of August 2020, the DSP conducted investigation, and during the course of which the petitioner joined the investigation. And thereafter, on 22nd of September, Savita and Kuldeep, they also joined the investigation. And while they did so, they brought before the police a photocopy of the comments which were left by the petitioner on Savita's Facebook post. And thereafter, their statements under Section 161 of the CRPC, they were recorded. So essentially, Section 161 provides for examination of witnesses by police. And thereafter, after these statements of the Savita and Kuldeep, they were recorded. The petitioner was arrested eventually, and thereafter, the petitioner was arrested on 24th of September 2020, and he preferred a bail plea or petition in the High Court under Section 439 of the CRPC, seeking grant of regular bail. Now, the case of the petitioner essentially revolved around two major arguments. The first being that the ingredients of the above stated charges or sections, they were not made out, and second being the petitioner has been in custody since 24th of September 2020. So now, having understood the brief facts, the nature of the offense for which the petitioner was charged or charged for, let's proceed with the reasoning and decision of the court. So the court at the very outset observed that a bare approval of the screenshots of the said posts, it prima facie revealed that the comments were indeed derogatory in nature, and they were made against particular communities, that is against Muslim women and also women belonging to the SC category. And secondly, the court further noted that the petitioner appended just one of the posts to his petition, whereas there were a number of other posts which were made by him which were objectionable, which were attached with the status report. And therefore, the court, while refraining itself from commenting on the nature of petitioner's post, held that freedom of speech does not entitle a person to make derogatory remarks or posts against any community or gender. So, this is the answer to our question of law, which is that freedom of speech, sure, is a fundamental protected or guaranteed right under the Constitution of India, but there are certain reasonable restrictions which are attached to this particular freedom. And in order to have a civilized society, a person cannot be he just left with the freedom without having any recourse to it. So therefore there are certain reasonable restrictions attached to it, and in the light of the same, the court made the following observation, that freedom of speech does not entitle a person to make derogatory remarks and post against any gender or community. And therefore, without making observations on merit, the court denied the relief sought in this particular petition, which is grant of regular bail. So that's all we have for this case analysis. At the end of it, you may find a list of abbreviations which we've used in the note. You may refer to it in order to have a clearer understanding of the note. And thank you for being with us.